Carl Lee Powell, he's in custody.
All right, pause. This is where things get messy. We're about to dive into a classic courtroom tangle overlapping, orders confusing bond conditions, and a timeline that refuses to cooperate as you listen. Try to catch how one tiny detail, the exact date of an amendment, ends up driving this whole showdown. Let's go.
It's a bail review setting. He has a felony attached, and I spoke to DVD about the situation, and it is a little confusing because it appears when he was in felony court, the residence that he's supposed to stay away from is actually his mother's residence where he lives. The complaining witness is like a roommate that he let a gentleman and this gentleman's girlfriend move in with him. And so
in her house
with the mom, with the mom. And then the allegation is that the complaining witness stated that he, assaulted her on a different occasion. And then that's when the charges were filed. So
complaining stated that Mr. Powell.
Yes, okay. Assaulted her.
Okay.
And then charges were filed. And he was given bond conditions, and at that time, like January 31st, a MOEP was signed, okay? And he had an ankle monitor. But the complaining witness then went to a rehab facility for crack addiction, I believe. And so when she was out of the house, he goes back to felony court. He goes back home. He goes back to felony court. The judge allowed him to amend the bond condition so he can go back to that residence.
Sure.
Yeah, that's when I spoke to DVD, but the problem was the MOEP was still in place when he went back to the house. So I think it's a violate bond condition and a MOEP. But since that time, I guess when he spoke to Judge Peebles, that he amended the bond conditions, removed the ankle monitor, and allowed him to go back home. In this court today, the violate the protective order is alleged to have occurred that the complaining witness went to the house where his mom lives to get her stuff because she was told she had to move out because her boyfriend now is in custody for a different offense. So she was asked to leave the residence. The mom didn't want her there. So she goes back to get her belongings. And that's when she encounters Mr. Powell's in the house because he's been living there with his mom. And so she does state, I think, in her in the probable cause that he did not threaten her or he did not assault her, but here we are. I mean, it's a black letter law, right? So obviously, I think everything's going to hinge on the felony case.
Yes, Judge, and we have notes as well saying that the felony court did remove that condition. It's just uncertain why they didn't amend it in the MOEP as well, but the bond condition was removed after it was found the complainant no longer resided at the
home. Holding him at no bond too.
Right, so.
I don't understand how.
And then that's what I'm saying, and he does go back to court on the 19th.
No?
For the felony.
With our case, the problem is that he's still in communication with her, which is still a violation, right? You can go back to the house, you just can't, and I'm assuming the only reason he could go back to the house is because she's in rehab and she's gone, right? But for her being in rehab, he still wouldn't be able to go there because I think the idea is that they don't have communication together.
And I think the date was the February.
And yeah. What I don't, the problem upstairs is they didn't try to anticipate if and when she would leave rehab to go back home, because if he's there, which he probably has nowhere else to go.
Right. According to our case, she was there to get her belongings, and that's whenever they came into contact with one another.
So ours is a good case then.
Yes, technically, because it's based on the MOEP that wasn't amended. So
no.
Because that's
no, but they still are having contact.
Yes,
that's the problem.
Just as
the fact that he's
just as pled.
Well, he lives there. She came over to get her clothes because she was kicked out. It's his mom's house of 40 years.
Right.
Yeah.
Right.
And then she came.
And his mom is a complaining witness.
No.
Who's a complaining witness?
Complaining witness.
He moved in basically to crackheads to the house. And it's a guy and the girlfriend. And then the girlfriend had to leave. And then the boyfriend of that girlfriend, it's not him. So basically he moves in two buddies, two friends.
Right. I get that. So it says here,
And the woman is the girlfriend of the,
one guy.
yeah, one
So
guy.
that's Miss Scott.
Yes, Judge.
Yes,
So that's Miss Scott's not.
not his
not-
mom.
not his
It's
mom.
not his mom.
Good.
So Miss Scott, those are the clothes.
Either, I don't know, I can't tell from the pleadings and what I've read, if it was before she was in rehab, after she was in rehab, or during rehab, when she goes back over there to get her stuff, because it indicates that someone told her she could no longer live there.
So it says here, did violate said order by intentionally and knowingly going to or near a place specifically described in the order to a residence of a protected individual, namely this address, right? I mean, if you're telling me that it was amended to where he could go there, I'm gonna find no probable cause.
So we understand because the bond conditions were
Right.
amended in the felony.
You want to take a look just to make sure? Because it will affect an upstairs case.
Absolutely.
Howell.
And Judge, what we have, and just to be clear, the bond conditions were
In place.
amended.
Yes.
The MOAB was not amended, and that's what this BPO is based on. Just to make sure that the facts are.
And then
There-
according,
There's two.
Was that an oversight on their part upstairs?
it appears
We
so.
don't know.
It may, probably was.
There's no note anyway.
But
Both
the bond conditions were amended for him to be able to go back to this.
To that same residence, Your Honor, yes.
And they removed his ankle monitor as well, so there was no exclusionary zone anymore.
And here's the rub though, they're holding him at no bond upstairs and then now for another 2 more days.
But the bond is removed. So,
I'm gonna find no PC. I mean, I can't,
This might be one I need to kind of go talk upstairs about.
do you want to email them real quick and see?
So
I mean, we haven't,
the DVD prosecutor did come down, and basically he was saying, obviously it all depends on the felony, but he also indicated that the MOAB was still in place when the
Place.
alleged.
Yes, Your Honor.
every right to be there because they amended the condition for him to be able to go back.
But I think they're saying the offense occurred before the amendment was made.
That's a different story then.
Yes, Your Honor. And so
Say that they amended the condition.
sorry, Your Honor, the other thing is this is a,
February 14th, and this office date
Oh.
is.
So what happened is when he went to the location, he got a bond violation. And so he appeared in felony court after that, and they amended it.
But he's still nevertheless,
Right.
Your Honor, before, I just asked for before
I'm not
a
going to.
decision is
Because this is the date, but it's the date before the conditions were modified. He still is going there when he's not supposed to be
Okay.
there. Right, okay.
But I was asked if he would reduce his bond.
It's at $500.
I know, can you reduce it to 100?
Let's do this. I don't know yet, because obviously he's still doing whatever he wants to do. And I have concerns, Why don't we set this for the 20th, which is the day after felony court? Let's see what happens over there. And if they give him a PR bond and if they're okay with releasing him, then
Your Honor, this is a DVD case as well.
Notice what just happened. The judge hit pause on everything. This is strategic. Instead of making a snap ruling on a murky timeline, syncing his decision with the felony court's next move. Smart, absolutely risky. Also yes, because this kind of delay can either clear a defendant or trap him deeper, depending on what the upstairs court does. What do you think? Is this careful coordination or a legal game of hot potato?
And so I'll have the DVD prosecutor.
Okay. Yes.
Okay,
So
so we're gonna roll it to the
I
20th.
would say, yeah, Thursday's the 20th so that we can,
Sounds good.
know.
All right, thank you.
I mean, if it was after, I'd find no problem because all day. No,
All right, thank you.
yeah. Are you ready? That's okay.
Mr. Matthew. It's a bond violation.
What's the last name?
Leonard. We owed him from Friday. Yeah.
Come up, Mr. Leonard. As of 3/4/25, you failed to get a portable device. When did you get it?
I got it, this is the second one. I had to take, my first one because it wasn't registered, just like this one's doing.
So, Your Honor, the long of it all is initially he had an order for an interlock. Doesn't have a car. This case happened. The date of the incident is like years ago. There was an accident. It was a 2B because he was hospitalized in the accident. There was a blood draw, determined that he was over the limit or whatever. So he comes to court and he's ordered to get an interlock, doesn't have a car, tells them he doesn't have a car. There's a bond violation filed.
The first one is because he doesn't have a car, so he just decides not to get a device, right?
No, Your Honor, I believe he was telling him, I don't have a car. I mean, in all fairness, I don't believe he knows that he's supposed to then say, hey, can we do the portable or something like that? I don't believe that I don't believe he understands that. I mean, now obviously he does because I think maybe about a week or so later, he was ordered to get the portable device. He went and got a portable device. I guess there were some issues with the portable device, and that's where this issue is coming in. He was supposed to get it by the 4th. It didn't come in until the 6th of March. And so he's gotten it. I've talked with the pretrial. She said there hasn't been any positive blows on it, but he's still saying that there's, it seems like it's not recording right or something like that.
So let's do this. So I'm just going to put a monitor on your ankle so I know that there are no issues. You know, I'll pay for it, but I'm going to put a scram monitor on your ankle so I know that there are no issues. Mr. Leonard, you must charge this thing on a daily basis. If you don't, if the battery dies,
Yes.
so will your bond. I don't want any more excuses. If you ever have an issue, you have a lawyer, will go to bat for you, but you can't just not do things because of what you want to do. There are orders in place and you must follow them, and that's it. Any more issues, we're going to have problems. You understand, Mr. Leonard? Okay. All right, we'll continue supervision.
Thank you, Your Honor.
Thank you, sir.
Right this way.
All right, hold up, brand new. Defendant, brand new charge, and this one comes with a mental health twist, a family confrontation, and a pair of scissors that instantly raises the stakes as the judge reads this out. Ask yourself, when does a mental health crisis become a criminal act, and how much should that matter in bond decisions?
Want to make sure. Counsel, come on.
Judge, I've got an off-docket matter asking the court to set bond on a case, please.
Hold on. What's your cause number?
It's going to be Jaden Bolding. His cause number is 255-4634. 255-4634.
Okay, give me a second. Let me make sure everybody
Yes, sir.
gets it. You got it? Yes. No. 255-4634.
255-4634. Yes, sir.
34. No, 4634.
Okay.
Okay, you want to bring your client?
Yes, sir.
I'm sorry, what was that case number?
255-4634. It's an off-docket arraignment.
We need a PSR on that one.
Yeah. Good morning, sir. Give me one second. Did you hear that?
Yes, I got it, but I haven't done the PSR.
Take it down. All right, good morning, Mr. Balding.
Good morning, Your Honor.
Mr. Balding, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 7th, 2025, in Harris County, Texas, officers were dispatched to a mental health call and met with the witness and the complainant, who are the stepfather and mother of the defendant. The witness stated that the defendant suffered from an undiagnosed mental illness, which caused him to get triggered. The defendant was triggered by clothes lying on the bed and started to argue. The defendant grabbed a pair of scissors, which the complainant took from him before the defendant struck the complainant several times, causing pain. I'm sorry?
Struck who?
The complainant.
I know. Who is
Stepfather, Your Honor.
The stepfather.
All right, Mr. Balding, I'm going to find that there's sufficient probable cause to go forward with your case. I am now entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Mr. Lawson as a protected individual. You cannot commit family violence or an assault against this person. commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate threat or harassing behavior. You cannot be in possession of a weapon. This usually comes with a residential restriction. We need to figure out, are they here?
They're not, but the state has
Your Honor, We
conferred.
have spoke with them and the complainant does want the defendant back at the residence.
I will take off the residential restriction.
Thank you, Judge.
How old are you, sir?
I'm 27.
You are not to consume alcohol, illegal drugs, or unprescribed controlled medication. And I'm telling you now that I'm going to test you for marijuana. If I find that you're using, it's not going to go well for you. Do you understand me?
Yes, sir.
I promise you, you're going to get tested. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. I'm going to give you a PR bond today so that you don't go to jail. But if I find that you become a danger to my community, I will do everything in my power to protect every single person. I don't care what your excuse is. I don't care what you're going through. If there are issues, now is the time for you to take care of them. I hope that this is enough of a wake-up call that I don't have to put you in custody, because we have enough people in there now as it is. What do you do with yourself?
Yes, sir.
Are you in school? What do you do?
I'm planning on going back to college, sir. But I cut hair and I produce and I engineer music, sir.
Okay.
Let's work at
You
HEB.
graduate from high
Oh,
school?
and I work at HEB. Sorry, HEB is like my job, but it's in career.
What about high school? Did you finish high school?
Yes, sir. I graduated.
It's time for you now to also start thinking of the future. The more education you get, the more money you're going to make in life. And I'm going to tell you, this life is so great if you have money, and it's so terribly awful when you don't. I promise you, the farther you go, the more knowledge you get, because knowledge is power. This is what you're going to get. This is not good. Now you have a lawyer. Have you signed on yet?
I will today, Judge.
I need you to sign on. I have attorney of records in the tower. You have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court. But you've got to stay in touch with him, and he'll tell you if and when you have to come back. You're going to get tested. Don't use. You understand?
So
Okay. Guys, bond, any recommendation?
We would ask for maybe a $500 surety bond, not anything
Do you have
significant.
any priors?
He has
no priors.
no priors, Your Honor. And due to the mental health concern of the case, we wouldn't.
Surety bond's going to do what?
I spoke to the DVD prosecutor as well, and that's what he conveyed.
Well, I'm going to give you a PR bond. I'll set your bond at $100.
thank you, Your Honor.
Just make me proud. That's all I'm asking you to do, man.
Sir.
So what we're going to do now is I'm going to have you go sign a reset with Victoria. We'll have you take a seat while we generate all the paperwork. You will meet with Felicia for your bond conditions, and after that, you're free to go.
Very good.
Thank you, Judge.
So can you file no threatening, harassing, and no weapons, please?
Yes, sir.
Mr. Munoz Puente, you are charged with driving while intoxicated. You are facing up to 6 months in jail and/or a $2,000 fine.
Dólares de multa.
You're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir. On July 4th, 2019, the officer observed a white Ford Mustang pull out of a Citgo gas station parking lot onto the 200 block of East Little York Road. The officer observed the Mustang failed to drive in a designated lane, driving over the striped white line in between lanes 1 and 2 multiple times while other vehicles were on the roadway. The defendant was unable to control its speed and accelerated and decelerated multiple times. A traffic stop was initiated. The defendant was observed to have red glossy eyes, slurred speech, and swaying while he was standing. The officer also observed a strong odor of an alcoholic beverage. The defendant admitted to drinking 5 beers, and standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. 2 spilled beers were found in the vehicle, and a search warrant was drawn and executed for the blood.
Why is this case 2,083 days old?
Just so
¿Por qué está
speaking to
cambiando?
him in 2019, he was arrested in the ICE detainer that was hit. He was picked up by immigration. He said when he was in the immigration court, they told him he could sign a waiver.
Voluntary
Yeah,
departure.
voluntary departure. That's what he did.
Deportación voluntariamente y
Mr. Munoz Puente, you want to find that there's
Vamos a
sufficient
averiguar
probable
es
cause to go
suficiente razón
forward with the
probatoria para
case.
seguir con el caso.
I'm ordering you as a
Voy a
condition
ordenar
of your
como
bond
condición de
not to
su fianza
consume
no consumir
alcohol,
alcohol.
illegal drugs,
Lo que solicitas
unprescribed controlled medication. I'm going to randomly test you.
Vamos a
If
hacer
I find that
testes.
you're consuming alcohol or illegal drugs,
Si
I
averiguo que
will
estás
revoke your bond
consumiendo
and I'm going to put you in
porque voy
jail.
a quitar la fianza y
I don't know
encarcelarlo.
what your
Yo no sé
immigration
qué es su
status is
estatus
now.
migratorio
You
ahorita.
now know what happens when you go to jail. They will possibly deport you. And I'm going to tell you, if you come back and you don't come back with the proper documentation, it could be 5 years minimum in federal custody on an illegal
Años
reentry charge.
mínimo.
So when you do things the right way, good things happen. When you don't, there's serious consequences. If I find that you violate any of these conditions, I will put you in jail.
Encarcelar.
Do you understand?
¿Se lo entiende?
On his license, see if he has a valid license, please.
There's no license on
No
file,
tiene
Your Honor.
licencia.
You are not allowed to
Él no
drive.
va a poder manejar.
That is my most important
Es
condition
la
in this
condición
area
más
now. If I find that you
Si
drive,
yo
I don't
averiguo que
care
estás
what you,
manejando, a mí no me importa qué
I
sería
can have a
esta razón.
contempt hearing. You can be facing an additional 6 months jail and $500 fine. I will have you sign with me now an affidavit. This is a promise that you're going to make to me that you're not going to drive. I don't care what is going on in your life. If you don't have a license, a Texas license, and liability insurance in your name, you are not allowed to drive. You run as NCICC as a priority to the eyes, please.
Yes, Judge, I'll run it.
Your case number? It's 226-7399.
Your Honor, it appears based on the NCIC, there's a pending DWI out of Dallas County as well.
Dice que es un condado de
That's correct, Judge.
Es correcto.
He does have another open
Tiene
DWI
otro
in Dallas
abierto
County. I
en
believe
el
he picked it
condado
up
de
before,
Dallas. Y
before this case.
Antes de este
But it
caso,
was a warrant for both of
pero
them,
había
which he was
una orden
picked
de
up
los
for,
dos que dos
I think they bond for both of
cuando
these cases. So
había
before
fianza,
he was deported,
antes de
he had picked
que
up
lo
both those
deportaron,
DWIs.
a todos los se le referencia de cuenta.
Did he get a PR bond in this case? Munoz Puente.
GOP, but it
La
was
fecha en la
row.
cuando revocaron la vacante
And then he posted
que faltó
a
en el 2019. Cuando fianza. Efectivo.
I'm going to put an ankle monitor on
Voy a
you,
poner una
and I'm now giving you a code
y le voy a
7
dar
to 7. If I
un
find
horario
that you're out
específico.
past
Si
7
usted
p.m.,
sale
I'm
después de las 7 de la noche.
I will do
lo voy a
everything in my
encarcelar,
power
voy a
to
hacer
protect
todo
the community
tipo.
at all costs. Do you understand?
No entiendo. ¿Contesta? Yes.
Unacceptable. Counsel, were you going to say something? If I find
Y yo averiguo.
that you test positive for anything, and I don't care what it is, if you try to come here and try to tell me that it's mouthwash, it's a tequila lollipop, it's hair dye, it's mustache ointment, I will literally,
Bigote.
you are driving a car. Holy moly, I will absolutely lose it. Do you understand?
¿Lo entiende?
Don't dare
Te atrevas
get near a
a
car.
acercarte a un automóvil.
So 7 to 7 curfew.
Después de 7 horas en su trabajo.
Scram monitor. No alcohol, no drugs. Is all discovery in?
Yes, Judge, everything did.
Okay. So counsel, I'm going to give you a 30-day setting. At that point, you got to come back and let us know what you want to do. And then you have 30 days to go through all the discovery with your lawyer. And you come back at that time, I'm going to either set your case for trial or you will accept the plea bargain for the agreement. But at 2000, and I know that the issues may have happened, but with another DWI open, it's time to do something about it. Okay, all right.
Thank you, Judge.
See you soon. So when was the first time we tested him?
I believe February the 13th. I'm sorry, not the 13th. It was 2 weeks ago.
2 weeks ago. I have a note from the 10th saying that he tested positive for THC. We were just awaiting to see confirmation from the lab.
The
'Cause
lab
he was-
confirmation is not come back.
When did we first test him, Lisa?
Judge, 1 second, please. For Diego?
When was the first, we ordered him not to use when he first got here, correct? This case has been on docket for 64 days and you've continued to use. I have ordered you not to use. You just tested positive. You first came here 64 days ago. I ordered you not to use and you tested positive yesterday?
Sorry, Judge, it's loading.
Take your time.
I have positive on January 17th and then a positive on 3/10.
He was, I know, I understand the test, but my client's very comfortable with me and he was quite confused as to how the results came up positive because
I can tell you why. Hey, I'm revoking your bond. You're going into custody. It goes with you. I told you. So here's what we'll do. We'll give it a couple days. I'll admonish him. Let him out. And clean out. If he cleans, great. If he doesn't,
he goes back in. Can a couple days be like Wednesday?
I'm okay with Thursday.
Okay.
Yeah, for sure.
And for Baptiste, I had filed a motion to withdraw in your queue.
Is he on land?
Huh? No, he's not on docket. But he doesn't have an attorney, so I don't know if the court wants to appoint. I'm just like,
I don't see him in the docket today.
oh, he's not. I'm just.
No. So we got to get him on the
Oh, it's
docket.
on the docket. And then
Right. I don't just grant because I've done it, granted, and the defendant gets here. Where's my lawyer? I just gave him
Got
money.
it. Okay, that makes sense.
So
On docket,
say
okay.
whatever you want and then we can do it.
Okay, thank you.
Ms. Wilson, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 180 days in jail to be probated for 18 months. As part of this agreement, you will do a DWI education class. Is it a true first state? You will do
It's true first.
you will do a DWI education class. You will do, I guess there's no victim impact panel. You will do a TRAS, which is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill them. Random urinalysis, no drugs, no alcohol, guardian interlock, 20 hours of community service, and a $100 one-time donation to the Houston Food Bank. Is this how you understand this plea bargain agreement? You need to understand that you're here on a bond violation today because you failed to appear for a drug test. If you do the same thing while you're on probation, I will issue a warrant for your arrest. And we're going to have a hearing as to whether you're going to be doing 180 days in jail. You have to do stuff on time and you can't skip. I don't care what's going on in your life. If there's a choice between probation and something else, what is the choice that you have to make? Right. Because if you don't, you could be facing a lot of time in jail and then you're not going to have your dog. You're not going to have your work. You're not going to have Cleophas. It doesn't matter. Probation is for a reason. And when you don't do probation, there are serious consequences. We issue warrants put people in jail, bring them out in orange, and we have a hearing to determine whether you violated. And if you do, by testing positive, not doing your stuff on time, testing positive, you're looking at a ton of time. The other thing that you need to realize is that this DWI will be going on your record, and it's going to be there forever. You ever get pulled over in a car and an officer comes to you and they smell alcohol and they run your record and they see that you have a DWI, it's probably not going to go well for you. From now on, you're also facing a minimum of 30 days in jail. No more proverbial slaps on the wrist. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, there's no changing this. This is what you want to do. How do you plead to the offense, man? Guilty or not guilty?
Guilty.
I'll find you guilty. Do you know what happened on the ALR hearing? Can you run our license, please, Alex? What I'm trying to allude to is that I don't know what has happened with your license. I'm not going to suspend your license, but it's very possible that it got suspended through the administrative hearing versus DPS. If it did, your license and it is suspended, you're not allowed to drive, and that will also be a condition of your probation.
Those are current ALR suspension, Your Honor.
So your license is currently under suspension. You cannot drive. If you drove here, you can't drive home. It's suspended. Do you understand? So get license back. Do you have children, ma'am?
No.
Okay. All right. Good luck to you.
Thank you.
Thank you.
Thank you, Your Honor.
All right. Coming up, gentlemen. All right. So who is Mr. Zion? Mr. Zion, you are wanted out of the state of Louisiana for felony carnal knowledge of a juvenile and misdemeanor sexual battery. Are you waiving formal extradition, sir? Mr. Dean. You were also wanted out of the state of Louisiana, you for second-degree murder, attempted second-degree murder as alleged. Are you also waiving formal extradition, sir? Okay, good luck, gentlemen. All right, good morning, Mr. Torres. Sir, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 1 year in Harris County Jail to be probated for 15 months. You will do a repeat offender DWI education class, 2 victim impact panels. You must also do a TRAS to see what other conditions you may need. You must fulfill all those conditions. If you don't, then into jail you will go. We will have a hearing. You will be facing a year in jail. You must do a TRAS, no drugs, no alcohol, guardian interlock, and 25 hours of community service. Is this how you understand the agreement, sir? You are giving up to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, there's no turning around. What happens on the next one? What happens?
Jail time.
No.
Enhanced, yeah, felony.
Prison time. 2 to 10 in the penitentiary is what you will be facing if you ever pick up another DWI. If I were you, even a sip of alcohol, I wouldn't get into a car. You need to understand that this is big business in Texas. And now there is also a surcharge that you will be required to pay because of this. Is it true or untrue that it is a 0.15 or above? True the enhancement. You will be required to pay the $4,500 surcharge plus court costs that will be assessed in this case. And I'm going to tell you now, if you don't, every $100 that you owe, you will sit 1 day in jail. Do you understand?
Your Honor.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, you are stuck with this. You can never change this. You understand?
Yes, sir.
Is this what you want to do?
Yes, Your Honor.
How do you plead to the offer? Or how do you plead to the agreement? What does he have now? Does he have a guardian anymore?
Yes, he does, Your Honor.
You get the case number?
No, I think.
Okay.
It's all right.
I had it up and then I was like, maybe she has it. It's 2522036.
Okay.
Hey, Mr. Messina.
Señor Lucina, buenos días.
Mr. Messina, you were
Señor Mess-
charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they are offering you 45 days in jail with credit for the 15 days that you have done.
¿Y ya se río?
You need to understand
Necesita que
that there is an affirmative finding of family violence in this case.
el caso que ocurrió.
What that means is that you can never own a gun or ammunition as a result of this case.
Arma de fuego o por este caso. Okay.
Also, if you ever pick up another one of these cases again,
Caso como
you will be
este,
facing a third-degree felony, a minimum of 2 years in prison,
lo
a
mínimo.
maximum of 10 years in prison. Do you understand?
¿Usted lo entiende? I understand.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law.
Bajo las leyes federales. I'm a citizen.
You give up the right to appeal.
A una apelación.
Once you accept this agreement, you're stuck with this. It will go on your record. It will be there for the rest of your life.
Vivir por todo su vida. Understood.
Knowing this, do you still want to go through with this plea?
Sabiendo todo. ¿Quieres seguir con esta declaración? Yes.
How do you plead to
¿Cómo
the
te
offense
declaras
of
a la
assault of
ofensa?
a family member?
Mi propia
Guilty
vida.
or not guilty?
Guilty.
I will find you
Voy a
guilty.
hallarlo culpable.
I will sentence you to the agreement.
Sentenciarlo a-
Does this take care of the case upstairs? As a result of you pleading guilty to this offense, the injury to the elderly that you have, the felony case is going to get dismissed. I will tell you now, there's not many times that agreements like this will be offered. So if you are a person that has lack of self-control issues, find another way
Averigua
to
otro
deal with the aggression.
para
People,
la que
children, that's not the right way.
somos una luz.
Yeah, okay.
Las cosas.
All right. Good luck to you, sir.
Buena suerte, señor.
Thank you, Mrs. Saldana.
Thank you, Judge.
Okay, are you ready, Ms. Strong?
Aquí.
So let me come up.
Jogi, David.
So let me get this straight. You plead guilty last week to a terrorist threat. I told you as part of that not to go back to the location. The day after you get out, you go back to this location, you pick up a violation of protective order, and now you want me to take a time served? Really?
Sorry to interrupt. It's not a time
Yeah.
served. It's a 1 year in Harris County Jail. That's the maximum sentence. And I spoke to the complainant. That's what she's requesting. And
Okay.
Yeah.
But first, I would like to have him TRAS'd because I want to know how to go forward. Because the problem is that this has now become a revolving door where it's in and out and over and over and over. We need to figure out why. And this, the fact that you just keep going to jail over and over and over, why? Let's get to the root of the problem to figure out why. Why do we have these aggressions? Why do we have you keep coming back? That's what I'd like to do. Enough of this, you know? So, can you please, I'd like to set it for TRAS to see how we go forward to figure out, so we stop. I mean, literally, Mr. Lopez, and I did this with you last week.
I understand, Judge.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. No. The time has come to stop. Okay, thanks. We'll try to get it done as quick as possible. I'll expedite you because you're in custody. Just be honest with these people. They're going to come evaluate you. Be honest with them. If I get the report back and it says that they're little bunnies jumping in the woods, that there's no issues, I'm gonna send you right back to do it again because it's just not true. Okay, thanks. All right.
Your Honor, I am here on Miss Jessica Sanford. We had Miss Jessica Sanford here on an assault case. She picked up a felony PCS, Judge.
Ms. Sanford.
You can't come to court like that no more.
Did you think you were coming to the club today?
No, sir.
This is a courthouse.
Yes, sir.
I don't see a disco ball, man. For real.
I just got off
Don't
work.
come like this again.
Yes, sir.
I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. And I want to send you for a test now.
Yes, sir.
I want to know what, if anything, that you're going to test. And if I find that you pick up any new cases, I'm going to go absolutely bonkers on your bond. Do you understand me?
Yes, sir.
I'd like to send her for a test now and have her come back.
Yes, sir.
Judge, also she spelled on her second no-show for copy. She spelled to appear twice.
I've called them the day of, and they've rescheduled it for April the 14th.
Can you verify it? Can you
Because-
verify that?
Yes, sir.
We'll now make that a condition as well. Okay,
I'll send an email.
please. Okay, Mr. D, or John D, come on.
Judge, I am approaching you on Ms. Crawford. And there are two things, Judge. There was a BVR notice sent a few weeks ago, and she
here?
Yes, she's there, Judge. She's in the, you want to bring her up, or do you want me to just? It was for a.
Sent her for a test as well. She failed to go for one.
Right, Judge, just want to let you know that she didn't have transportation, her car broke down, but she went right back the following day to try to do it. And it's all documented, she emailed me and all of that stuff, text me, not, right, so I told her that, and so she did try, it's my.
Come up, ma'am.
Judge, she was sent for a drug test already.
Okay,
For Crawford?
yeah.
It's negative drug test, Judge. So.
Thank you for testing negative. Good job. The next time you miss, don't. You have a lawyer. We've given you a lawyer. If there's ever any issues, reach out to him and he can help you out. If they call you again and you miss again, it's not going to go well. Okay? All right.
Judge, the other thing I want to let you know is she is like, PTI bound. We had a miscommunication because she sent me her application, but it went into my junk mail. So I never got it, but I found it today. We just need a little bit of time for me to forward that and enact it.
Yeah, you got it. Okay.
Thank you, Judge.
For application?
Yes.
Judge, we can do it.
Well, I've got the application.
No,
It's done.
Oh, it's done.
I need
It's
to,
not submitted.
right, because
Okay. Guys, you ready? Thanks for being patient.
Yes.
It's going well, Judge.
Tell me
Yourself?
something nice.
Yeah, Judge. We're here on Disaki, Dissake.
Okay?
He's getting us mitigation, Judge. He's in good contact.
No, you've had it till December. He doesn't have it done still?
He's gotten some things in.
Please, is it yes or no?
To me today.
No, Judge.
And I'm rolling it to tomorrow. And I'm gonna roll it every single day until he gets it done.
The only thing I asked, Judge, is I'm out of county tomorrow. Can we just at least
Zoom.
Can we do it Wednesday? But it's not a,
He's gotta be here. You can Zoom.
Okay.
I have Zoom for you. But since December, we're
Yes, sir.
now in March 17th.
I
You want a back rub too?
can,
Really? Not you.
I can't make him,
No,
Judge.
so he's coming back tomorrow and every single day until he gets it done. Okay,
Let him know. Thank you, Judge.
I love you, man. All right, ready?
So reapproaching on Mr. Gonzalez.
Mr. Lord Crawford, you're charged with. Oh,
Is John D on Zoom? Not,
oh,
I can email him.
he's on bond for theft and now he picked up a new case. Am I right?
Yes, Judge, the DVR was filed on the 12th. Hold on, Judge, I'm looking at the
No.
wrong one. Are you looking at Crawford, Lord?
Lord Crawford. No, okay, he's on felony probation. That's what it was. Mr. Crawford, you're charged with theft. You're charged with evading arrest. You're facing up to a year in jail and or a $4,000 fine on the evading case. You're facing up to 6 months in jail and or a $2,000 fine on the theft case. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. What time did he get to court today?
Judge, I'm not sure, but he was definitely late. We marked everybody in one color, and when it switches colors, then we.
Court starts at 8:30. It doesn't start at 9:02, 10:22, 11:51. It starts at 8:30. Do you understand?
Yes, sir.
No, I'm just telling you for future reference.
Yes, sir.
It starts at 8:30. It doesn't start at Mr. Crawford's time, our time.
Yes, sir.
Yes, Judge. On March 11th, 2025, officers were dispatched to a theft in progress call and made contact with the complainant, the asset protection employee, who advised that multiple males were inside the business and were actively stuffing items inside bags and their pants. Upon arrival, the officers were in a fully marked uniform and fully marked patrol vehicles and saw two males run outside the store location. The defendant was observed carrying two shoe boxes while running. A foot pursuit commenced and the defendant dropped the shoe boxes and continued running for approximately 120 yards. The defendant attempted to jump a gate, at which point he was detained. The officer reviewed surveillance and observed the defendant enter the store, grab the shoe boxes, and then run past all points of sale while holding the stolen items. The total was $229.98.
Where from?
Gonna verify that. I see WSS is the name of the business.
It's a retail store, Your Honor.
Do you have co-defendants?
Let me see, Your Honor. No, Your Honor. There's no other connected cases.
Mr. Crawford, I'm going to find that there's sufficient probable cause to go forward with both of your cases, and I'm ordering you not to go back to the store. I'm also ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're using, it's not going to go well for you.
Yes, sir.
What do you do for a living?
Currently trying to go back to school.
So what are you doing with yourself nowadays?
I'm helping my dad at home. He's
Time for you now to get a full-time job?
Yes, sir.
Back in 2 weeks, and I want to see what you have done. If you've done nothing on either case, it's not going to go well. Do you understand?
Sir. Could I ask a question?
I'm not here to play around, and I hope that you're taking this seriously. You're on felony probation, and you're looking at up to 10 years in prison, and you've now picked up 2 cases. It's very possible they file a felony warrant for your arrest because of these 2 new cases, and you could be sitting in felony court for a very long time in custody because of these 2 new cases. Do you get my drift?
Yes, sir.
Straighten up and fly right, or it's not going to go well for you. So we'll have him fill out an application, and then I want him back in 2 weeks. I'm going to test you. Get ready. If you use, it's really not going to go well for you. If you pick up a 4th case, I will absolutely lose my shicer. Do you understand?
Yes, sir.
Okay, come on, Deputy Miranda, please. Mr. Horn, you are charged with harassment. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On March 6, 2025, the officer was dispatched to a residence in Harris County, Texas, in response to a telephone harassment type call. Upon arrival, the officer spoke with the complainant, who stated that the defendant is the complainant's ex-husband, saying threatening messages toward her, such as, "You better watch your back," and "This is a threat." The defendant advised the complainant to kill yourself, and the officer also observed a message saying, "You better run for the rest of your life because you're fucked." The complainant advised the officer that these messages did place her in fear of bodily injury, and the officer observed ongoing messages from the defendant.
Your Honor, may I speak?
No.
Yes, sir.
But may I do the probable cause? May I add some probable cause?
So we have here the complainant that she's been receiving many text messages on her cell phones by the defendant, who's a complainant's ex-husband, saying, you better watch your back. This is a threat. I guess he told her to go kill herself. What else? Did you have something you wanted to add?
Well, the other thing I wanted to add, Your Honor, was after the law enforcement officer spoke with the complainant, it calls the defendant. Defendant told them he was angry, didn't want to hurt her, and then after they got off the phone, he texted the complainant 8 more times.
Okay. Mr. Horn, I'm going to find that there's sufficient probable cause to go forward with your case. I see a dismissed, hey, Blaze, I see a dismissed aggravated assault. Tell me that's the same complaining witness.
It is the same complaining, let me just check, Your Honor, but it's the same name.
Mr. Horn, I'm going to find that there's sufficient probable cause. I'm now going to put an ankle monitor on you so I know where you are at all times and you're not to have any contact with this person whatsoever. If I find that you have any contact, and I don't care what it is, I don't care if it's Fortnite, I don't care if it's Snapchat, I don't care if it's text message, I don't care if it's a smoke signal, I don't care if it's your aunt from your cousin's three times removed. If I find that you tried to contact her from any means, I will deem you a public danger. I'm going to put you in jail and I'm going to make your bond so high it'll split the clouds. Do you understand? I will do everything in my power to protect my city at all costs. I don't care what color. They're a small farm animal. I don't give a rat's behind. Don't say anything. The only thing I'm trying to impart to you is that life is way too short to live in a 6x9 box because of a person, a thing, woman, whatever it is. Get over it. Do you understand?
Yes, sir. That is the second question, Your Honor.
Right. Because of the aggravated assault, I'm going to put a GPS monitor and I'm going to order no contact, no going within 1,000 feet of where she lives or where she works. Would you mind reaching out to her, letting her know all the conditions that we've set forth so that she knows, in the event that we have further contact, we can take the appropriate action, please?
Absolutely.
I'm also ordering you, Mr. Horn, not to be in possession of weapons.
Your Honor, may I please just say something?
You have the right to remain silent.
Yes, sir.
Now is the time for you to exercise that right. I know you want to say something, but that's why we have lawyers. You will get a lawyer, okay? You can explain your side to the lawyer, and the lawyer can talk to the DAs. They can talk to me. Now, this is not the appropriate forum. Mr. Horn, I'm telling you, I know that there's always two sides to the story. And if there wasn't, you'd be in jail right now.
Yes, sir.
You know what I mean?
I understand.
Right. You are out in the free world now. The only thing I'm asking you to do is don't have contact with this person. I'm not asking you to split the atom, not to do Pythagorean's theorem. Don't have contact. It's extremely easy. I don't care what you have to do. I don't care what you have to say. There's no justification you can give for trying to contact this person. Do you have a child with this person?
2, sir.
Okay. So you need to use an intermediary. That's what you need to do.
I'm just trying to divorce her. We're not even divorced, sir.
I'm not going to talk to you.
Yes, sir.
I
Yes, sir.
don't want to talk to you. I do want to talk about it. As a father, you should have access to your child. Every father should have full access to their child, just like the mother. It doesn't matter if you're wearing pants, if you're wearing a skirt. None of that matters. You should get access. But I don't want you to have contact with her and using the kids as an excuse. You need to find an intermediary somehow. How old are you?
29. I have suppressors. I have SPRs. What do I do with all that stuff, sir?
Stop.
You ordered me not to have weapons, and I...
Correct.
Yes, sir.
I don't want you to have weapons. So, do you have the ability to hire a lawyer?
I have 2 working for me right now. One's for the divorce, one for some speeding tickets. I can hire a 3rd lawyer, yes, sir.
Yes, sir. I'm a concrete plant manager.
Okay, so what I can do is I can give you an application for an appointed lawyer to see whether you qualify. I don't know. I give lawyers to nearly everyone here so that there's no excuse. But you still have to qualify because there are guidelines that I have to follow. So Deputy Miranda will give you an application now. I can have you fill it out. I will take a look to see whether you qualify. If you don't, I just can't give you a lawyer, right? And you'll be required to go hire lawyers. So, but be it as it may, don't have contact with this person. I don't care that you have children with this person. Don't use that as an excuse. You need to understand that I know that you want to see the kids. There's got to be a way to work it out, but no means no. You're the one that's going to end up in jail. All right, Deputy Miranda is going to give you an application. I'll have you sign a reset with Victoria. We'll have you get with Felicia for your bond conditions. Then I'll take a look at the application.
Judge, how much is the bond?
Ms. Brooker, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you a 10-month deferred adjudication, which is a type of probation that if you complete successfully, you do not end up with a conviction on your record. You give up nearly every right known to man by entering into this agreement, Ms. Brooker. And I want you to understand that if you are on this probation and behave the way you have while on bond, it's really not going to go well. And if I find that you're using and you do things, you could end up in a treatment facility. Do you understand? That is a lockdown facility for a minimum of about a year if you respond well to treatment. If you don't, it could be a 15 to 18 month program. Do you understand? So when we mean no using, we are absolutely serious. When you have classes, you have to do them on time. When you have community service, you have to do it on time. As part of for you to complete this successfully, you must do an effective decision-making class. 4-hour anger management. You must also do a TRAS to see what other conditions you may need. If they assess other conditions, you must fulfill them. No drugs, alcohol, 20 hours of community service, and a $100 one-time donation to the Houston Area Women's Center. Is this how you understand it?
Sure.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead, you're stuck with us until you complete successfully or you get revoked. You also need to understand that there's an affirmative finding of family violence. If you ever pick up another case like this, you will be facing 2 to 10 at the penitentiary. Do you understand?
Sure.
Did you graduate from high school?
Well,
That's what we
Do you
do.
think Papa's now?
Instead of the community service, waive it. That to me is the
Yeah,
absolute most important part of this.
So she's enrolled currently in the GED program.
Wonderful.
Wait, I've been doing the classes.
The minute you get your GED, I'll take you off. Well, got to finish the class. Right.
Okay.
But I'm saying the minute you finish and you get your GED, we'll take you off. So if you get it in a couple months, we'll take you off in a couple months. We'll take you off early if you do well. But I'm going to tell you now, if you do poorly and you continue to test positive, it's really not going to go well for you.
Sure.
Okay? All right. Waive all our fees. It's never about the money. I don't care about the money. Just do what you say you're going to do. That's it. All right. Good luck.
Thank you.
Thanks, Judge. Ready?
Yeah. Judge, sorry, I had one more on docket. Sorry about that. I also had Robin Parks on docket, Judge.
So eager to get.
Right. I understand.
Okay.
Yes, sure. So essentially there's an offer of the max 1 year in jail, Judge, or they would refile it potentially as a felon possession.
Today's the day to decide.
Right. So she's rejecting the 1 year max offer.
Are you going to just refile it then, or because I'm going to set it for trial now?
I'll refile it, Judge. I'll give a grand jury date here next week.
Okay. So what do you want to do? You want me to just? I'm going to set it for trial now.
I guess if 30 days is okay.
Yeah, no. I mean, I have to give you at least 30 days. So we'll do.
Attorney Warren?
I think it's got to be April 29th.
And Your Honor, I'll alert the court as well as defense counsel whenever I am able to get that case in the grand jury.
Are you really going to indict it?
I think it's.
Well, don't answer. So, all right, so we'll set it for jury trial, April 29th.
Yes, sir.
Okay. Robin Parks, come up. Today's a plea deadline. I'm not taking anything, like, if we set this thing, we're going.
I don't think that'll be an issue.
Okay. Hey, so the 22nd in April, that's a short week, right?
The 14th of April.
So can I set something on April 22nd then?
Yes.
That, what week is Good Friday?
Huh?
What week is Good Friday?
Good Friday is the week of the 14th.
Okay, so we'll set it to the 22nd then. I want you to know that today's your plea deadline date. I'm not going to take this thing where you're pleading on the day of trial and everything. No, today's the day that you need to decide. You either accept the plea bargain agreement from them or we're going to set up for trial. If you set this thing for trial today, we are going 100%. I will not take any more offers past today's date. I will give you time to go talk with Josh to see whether you want to do that today. But if we set this thing for trial today, you will be put to trial. Do you understand? Okay.
So and we've had this conversation, Judge, in the hallway. We were able to, and I can check and make sure
So
that Ms. Parks feels comfortable. But
okay, so April 22nd, jury trial. All right, thank you, man. Okay.
thank you, Judge.
Judge, I'm approaching on Alator Arisdelsi. Her bond was revoked on Friday.
Come up, ma'am.
And she bonded out, and so I know you always need to report to court the day after bond, the next available day after bonding out.
Now I'm going to test like crazy and ensure that she's not using.
Yes, Judge.
So ma'am, get
Yes,
ready.
sir.
You will be tested a lot. If it continues to happen, I will continue to do the same thing over and over. And all you're doing is you're enriching bonding companies. Do you understand?
Yes, sir.
So you're going to be tested like crazy. If you fail to show up, a warrant will issue. So,
I
all right.
understand.
Okay.
So Judge, do you want me to get like a 2-week for her to be tested? Okay, thank you, Judge.
No, but understand, it's going to be random. So
Oh,
you can
of
get a
course,
2-week
Judge.
reset, but you're going to be
I
tested
understand.
before that.
Yeah, I assume it's random and, both, Judge, yes.
All right. Good luck. I need you, hey, Blaze,
Yes, sir.
Mr. Horn. I'm giving you all the benefit of the doubt. I'm going to give you a PR bond today. The state doesn't want me to give you a PR bond. I'm going to set your bond at $5,000 and I'm going to give you a PR bond. If you make the slightest move to violate any of these conditions, then I'm going to yank the PR bond and you will end up in jail. Your bond is set at $5,000.
Sorry.
I'm giving you the benefit of the doubt now. You are not to use the co-parenting app at all. Do you understand? If I find that you do, no means no.
So I can't see them.
You cannot use the app because you're not to communicate with this person. Do you understand?
How can I FaceTime my kids then?
I don't know, but I don't want you to have contact with this person whatsoever.
Yes, sir.
What you need to do is give a list of the conditions to the family court lawyer and you go from there.
Your Honor, I'm here to inform the court that my client tested negative. Mrs. Sanford, Mrs. Jessica Sanford.
Good job testing negatives. Good job, really. That's all we're asking. Don't get in trouble anymore. Because I'm going to tell you now, you're on bond for the other case. You're going to get tested a lot more, as you will in here. Stay out of trouble. Did you get a new date for the eval?
No, sir, Judge, I have to do that. We have to,
I called Helena and she said because of the second no-show, they closed her file out and a new order would have to be.
Okay, so let's do a new order just take a seat for me, man. Take a seat. Do you need a new one?
I have to have a new, it's the third time, upon the third request, you have to put a new order in, so I can do that right now before I leave the day, Judge.
It's for conflict, right?
We'll keep that out.
I can do that. Yes, sir.
I mean, if you,
Well, let me get you to sign a copy just in case you're gone, you know what's on. That's okay. So I won't have to hold you. We'll do it tomorrow.